Hi guys, welcome back to Battle with Ola. This is Mujala Olua, and that's where the Ola is from. Today we want to talk about how to defend a crime. And of course, if you have seen my Cotonou videos, you would know that the room that I stayed in Cotonou was white, and so it had an effect on me. And when I came back, I decided to do up my place and make it white as well. I hope you love what you see. I love it. It's coming up really good. I'm still working on it, but I like what I see already. So let's get right into the video. This video is very useful for you if you're a lawyer, if you're a layman, or if you're a law student. A lawyer because if you're a defense counsel, and hardly would you be a litigation lawyer without you being a defense counsel at some point or the other, except you go to maybe a corporate commercial law firm, and so it will be useful for you to defend your clients, to prepare your strategy. It will also be useful for law students to understand, how crimes are defended in Nigeria. I've done a video on how crimes are prosecuted. So this is the flip side of that video. And of course, for laymen, whether you are charged with an offense or not, or someone, your loved one, is charged with an offense, it will help you understand the workings of the court and the workings of your lawyer. So very important. Let's talk about how to defend crimes today. The first thing I want to just go over how crimes come about. Because it's not every time someone does something wrong that we can say that a crime has been committed. We can only say a crime has been committed if that thing that the person has done is codified in a law, a written law, as a wrong that is punishable. So a crime must have punishment. So if someone has done something wrong and the police have been involved in the matter, and then they have arrested the person, and then they have preferred a charge according to the punishment section of the law that prescribes that activity or that offense or that event or that action that the person carried out, then we can say that the person becomes a defendant. Once a charge has been preferred and filed at the court, whether it's at the magistrate court or at the high court, then a person becomes a defendant and needs a lawyer in most, if not all cases. I doubt if you can defend yourself out of a crime in Nigeria. You need to get a lawyer. So once you get a lawyer, your lawyer is called your defense counsel. And on the other side, we have the state. And I've talked about that extensively in the video on how crimes are prosecuted. But how will your lawyer defend you out of this crime? That's what we want to talk about. So once you've been charged with an offense, you get a lawyer. And these are some of the things that the lawyer needs to do. So I'm going to be talking about it in no particular order, really. And I say that because once I go through the preliminaries and then I begin to talk about the strategies, I'm going to be going in and out of different types of strategies that you can employ. I'm not going to number it maybe numerically, I'm not going to list it out in any particular order, but these are the preliminaries. The first is that a lawyer is briefed. Then when a lawyer is briefed, the first thing the lawyer needs to do is to find out if it's a bailable offense or not a bailable offense. And that would come up when he interviews you as his client. So client interview. And I said client interview is the first thing, but I think the first thing should be trying to get your client out of custody if possible. So if it's a bailable offenses are offenses wherein the accused person or the defendant can be given bail pending trial. So your lawyer will file a bail. In fact, there are some lawyers that's all they do in a matter. Once a case has been filed or charged to court, they just come get your bill and they disappear. They can be likened to those people who call charge and bail lawyers. They have their reasons and they have what they do. It's not the best practice, really. I think that if a lawyer takes the bill, the lawyer should be ready to go all the way. But it is not in all cases also that a lawyer would be ready to go all the way, or that you as a defendant would want your lawyer who took your bail to go all the way. So, different things come into play. But once the bail has been secured, then we can now talk about defending the case itself. But if it's not a bailable offense, that means that they will go straight into defending you without even bothering about securing your release. So what are some of the things you should do if you're a defense lawyer? You should get the charge sheet and the proof of evidence. The charge sheet is, I've done a video on charges, so you should understand if you've seen the video. A charge sheet is a document, a paper or two or more, showing what offense you've been charged with and the punishment. So it will show so person at this so hour on this date committed the offense of so and so punishable under so and so law. So they would list the charge. It could be 1 count, 2 counts, 3 counts, it could be 20 counts, as many counts as possible based on the investigation conducted by the police and the advice rendered by the office of the DPP, that's the Director of Public Prosecution. So depending on that, the charges, the counts can be more or less. So as a lawyer, you should get the charge sheet, then get the proof of evidence. The proof of evidence is other things attached to the charge sheet, like the list of witnesses that the state wants to call. Now, when I say state, you need to understand, especially if you're a layman. I know lawyers, law students should understand this already. So you need to understand that the state is the one that prosecutes crime. So when a person has committed a crime, it is only the state that can charge the person to court. If it's a civil wrong, then an individual can file, a claim. But if it is a crime codified by the criminal code or some other criminal law, the state has to be the one that will charge the person to court. And by the state, I mean the office of the Director of Public Prosecution. So if they have charged the person to court, then the defense can now come in. So you can get a private lawyer to defend you. Or if you are indigent, you can get legal aid services, or you can go to the offices, or you can go to the office of the public defender, or there are some organizations that offer pro bono defense. You can go to them and then they would defend you. That's if you cannot afford a lawyer on your own. So the proof of evidence are those other things that the state attaches to the charge, like the list of witnesses that the state intends to call, during the trial, like what else? The statements of the accused person, statements of the witnesses, all the statements taken by the police that are relevant to the case during the police investigation. They are usually also attached to the charge sheet, and every other thing that can facilitate the state's case, they would attach it to the charge sheet, and they are to oblige you a copy. Usually they are to serve you a copy, serve it on the defendant, who will then get a lawyer and give his lawyer. But if they have not done so, once you come into the matter as a defense counsel, I'm saying this because sometimes, or even most times, state does not even bother to serve. So if you are the defense lawyer, meet with the state prosecutor and get the charge sheet, get the other proof of evidence, and then look through it, study it, so that you understand what your accused person is charged with. I have not mentioned client interview first for a particular reason, because if I say client interview, you could talk to your client and he could say that, oh, they arrested him for murder, or they arrested him for receiving stolen property. But at the end of the day, when you get the charge sheet, it could be that he's been charged with manslaughter, or he has been charged with armed robbery. So the first thing is for you to get the documents that the state has filed in court, so that you understand what you're up against. After that, you can conduct your client interview. So client interview is where you go to jail to meet with your client. You go to the prison or correctional facility where your client is being held, because usually your client will be held in custody until you come to court. Or if you have taken the first step that I talked about, that is getting your client's bail, then you should you can meet with your client in your own law office, or wherever is convenient for that purpose, and then you can do your client interview. So during client interview, you ask your clients all questions that can elicit information that you need to defend him. Where was he at the time? So the charge sheet will show that at so time the offense was committed. Where were you at this time? When did you leave the place? When did you get to the place? Who are the people that saw you there? Were you at the scene of crime, or were you somewhere else? Then did you commit this offense? What exactly did you do? So it could be that the person is just a victim of circumstance, for instance. So, or it could be that the police or the state is just using or it could be that the police is just using circumstantial evidence, for instance. You know what circumstantial evidence is? Oh, I should talk about that in another video. It's one of my favorite aspects of law. So circumstantial evidence basically means that the police is joining A and B together to arrive at C, not that they have cogent evidence or they saw what really happened. So for instance, if someone has been robbed of a blue car of certain make and whatever, and then they see you coming out of a blue car, and then they arrest you for stealing the car. So they are assuming that, oh, this is the blue car, why are you coming out of it? The person has just been robbed of the car. So that's circumstantial. It's not as if they saw you actually taking the car from the person at gunpoint or weapon point or something. So that's circumstantial. So you interview your clients as a defense counsel to find out all that you can. Have you done this before? Are you a known or notorious criminal? Do you have any criminal record? Or maybe the police has even caught you for this before. Are they repeating, are they repeating this arrest, or is this an arrest without cause, or is this just a case of, or is this an arrest without cause, or sufficient cause, or is this a case of police just rounding up people and then just filing a charge even when they did not catch you with anything? So you ask all questions possible according to the charge sheet so that you can elicit the information that you need to defend your client. After you might have interviewed your client, he might have mentioned some people who can bear witness to the fact that he did not do it, or he did it or did not do as much as he's been charged with, or whatsoever else they might want to say in his favor. So it's time for you to assemble your witnesses. That's the next step. Assemble your witnesses. If he has an alibi, for instance, I've done a video on alibi. That is, if he's saying that he was at someplace else when the offense happened, then you need to get people that can testify to the fact that this man was here, was doing so and so, or this woman was here, she was doing so and so at this particular time that the state is saying that the offense was committed. So you assemble your witnesses, people who can testify, to his uprightness, his good character, if it comes to that, because there are so many things you can use in defense. People who can, plant doubts in the prosecution's case. Witnesses generally, assemble your witnesses. That's the next point. And of course, the last but not the least point is prepare your strategy. So here, I'm going to be listing out the different strategies that you can use, in no particular order. But the next thing is for you to prepare your strategy as a defense counsel. More often than not, I've encountered, defense counsel who came to court thoroughly unprepared, having no, cut out strategy to defend their clients. Sometimes, most of them even bank on the fact that the prosecution of the state is not usually serious. So they would not even go to trial, or they would not even go on. I think I've told you on this channel before, sometimes that, we were in one matter, and then the other party had banked on the fact that we were unserious as the prosecution, and we would not do anything. And then we decided to shock him. It was a day of surprises because we had our witnesses assembled and we were ready to go to trial. And then he had to beg the court. Different things. You need to prepare yourself as defense counsel. Sometimes when I see movies about crime prosecution and defense in other jurisdictions, I see that a lot goes into preparing for defense. But my experience in Nigeria, and I'm being honest now, is for defense. I've seen it's so often that defense counsel comes to court just to wing it, just because they believe that the state will not be able to prove their case. So what if the state is serious with this one? Okay, we know there are several inefficiencies affecting, the state or prosecution of crime in Nigeria. But you never can tell. What if the state is able to overcome, the bottlenecks, that they usually encounter in most cases? What if in your particular case, they are able to overcome it? And it's a serious time and they are able to get their act together. So are you going to jeopardize the future of your client just because you thought you could wing it? It is never a great strategy for you to go to court as defense counsel to wing it. It might not work well, not just for you, but for your client, because crimes are serious in the sense that somebody's life and future hangs in the balance. Even if you think that, oh, I am going to appeal it, do you know that the person will first go to custody, go to jail, and then you now have to file for stay of execution, and then you now have to appeal? More time, more resources, and the person's time and life wasted. And the thing with most correctional facilities in this side of the world is that they're not really correctional facilities. So once someone has gone into jail, by the time they come out, even if they spend a few days, they are usually never the same again. So it's important for you to take your client's matter serious. I've told you on this channel also about a death sentence, that a judgment that was delivered, which was clearly a case of the defense, being unprepared, because clearly the defense that he could use were so visible to the blind, audible to the deaf, like one of my classmates used to say back in uni. But this man, I don't know if he was winging it or if he was pro bono and he didn't take it serious because the client was not paying. I don't know, but you know, he just made a mess of the case. The client got a death sentence and now he has appealed it. So it's not the best practice. Let me stop defense bashing and go back to what we're talking about. So what are you going to do as a defense counsel? What strategy do you want to use? How do you want to put your house in order and get your client out of the mess? You know, that is what we want to talk about now. And the first thing we're going to be talking about here is attempting a defense. Defense. I should have done a video on defenses in law. But anyway, you know, so many things to talk about. This law never ending. Hallelujah. So some defenses are complete and some are not, in the sense that once you put forth a defense, some of the complete defenses, if the court agrees with you, your client will be freed, discharged, acquitted. But some defenses are not complete, in the sense that your client might not be totally free, or it may lessen your client's may only lessen your client's sentence, you know, reduce your client's sentence, mitigate, you know, the punishment. So defenses are excuses or reasons that you can give to the court why your client did what he did, why he did it, or why he did not do it, why the state has no case against your client, or why, although your client did it, he did it because of this, he did it because of that. So there are different types of defenses and we'll get to them one after the other. So before we even talk about defenses, let me just go through a few things that you should get out of the way first. I've talked about interviewing your client, and by the time you finish interviewing your client, some things must be clear. One, what is your client's story? And by story, I mean, what story are you going with? You know, what story are you going with? And I'm saying that not because I'm encouraging you to lie or to, you know, fabricate fiction. But what I'm saying is that, for instance, I'll give an example. If your client is a drug peddler, for instance, and then while at a bar, meeting up at a bar to peddle drugs to clients, or to you know, solicit to peddle it to strangers, for instance, a murder happens, and now maybe the police rounded up everybody and charged your client with murder. Now your client did not commit the murder, but it was also there for an unlawful purpose. By getting your client's story, the one that you would tell to the court, that you will lead him in evidence to tell to the court, you should be able to de-emphasize his unlawful reason for being present at that scene. Yeah? Except the police finds it out themselves and charges your client for that, you know, offense. Your story as a defense counsel should not put your client, the story that you run with for your client, the story, when you elicit your client's story, you know, the way that you finalize everything must make sure that you're not roping your client into another offense. So if the police has not charged him for the drug peddling, don't assist them. You know, don't put your client in that problem. So tell his story to prove his innocence in the murder that he has been charged with. Of course, you would have a moral right if you are so inclined, or a God-fearing right if you're a God-fearing person, to encourage your client, advise your client, and you know, talk to them about, you know, coming out of that way of life, the drug peddling way of life, because it's not a good way. But when you're in court defending them for the crime of murder, is not the time or the place for you to tell a story of how they went to that club to sell drugs. I hope you understand. So finalize your client's story. What story are you running with? The correct story, the true story that will take your client out of that problem, but that will not also create more problems for your client. So that's one. Then two, when you have gathered witnesses and interviewed them, finalize the witnesses' story too. What are the questions you will ask them, and what will they say to the court? What they will say to the court that will not put them in more trouble. For instance, if one of the witnesses, maybe your client was at a bar. Now let's stick to the example that I gave you. For instance, the client has been charged with murder, but he was not even at the bar where the murder took place. For instance, let's say it was somewhere else, hanging with a group of never-do-wells, probably drinking someplace else, maybe not even the bar where the murder happened, and maybe you want to run with the defense of alibi. I'll come to that. If these never-do-wells are also involved in other criminal acts, maybe one of them is a burglar or a pickpocket, for instance. When he's telling his story, he's not there to tell the court that he's a pickpocket or that he's a burglar or that they were having a gathering or an association of burglars or pickpockets. I'm not saying your client is part of them now. I'm talking about the witness. What is there to say to the court is that at the time when this murder happened at so bar, this man was with us. We were together drinking at so place, same time but different places. Not for him to tell the court that he was with them, an association of burglars, because that could compound, the problem. Because the prosecution will now, latch onto that and try to say that, he's keeping a company of criminals. He's probably a criminal too, that's character evidence and whatnot. But it has its nuances, and its acceptability in court and otherwise. But that's not where we're going today. So very important. So elicit your witness testimony first. Never take a witness to court that you have not prepped, whose story you have not heard. The court should not be hearing your witness's story for the first time as defense counsel. No, you should have heard it. Your client should have heard it, and you should have agreed on what the witness will say. Facts, truths that will bring your client out of the problem, and not the ones that will compound the problem for your client. So finalize. What story are we running with? What are you saying to the court? What questions will I ask you, and what will you tell the court? And then what questions will the prosecution likely ask you under cross-examination, and what are the likely answers that you should give? So finalize that. 3, is there any physical evidence or any provable facts that you need to prove? For instance, the alibi. The witness will be, maybe they were building together, and that day your client even sustained an injury at the time when the murder was happening at the bar. So that's a provable facts. Maybe your client was building with his colleagues who will now come to court as witnesses and tell the court, we were building together. In fact, he fell off from the ladder at some point. We rushed him to so-and-so hospital. These are the hospital bills. These are the prescriptions from the doctor. This is a doctor's note, a doctor's report. Those are hard facts, provable facts, to the effect that this person was not even at the scene of crime, talk less of committing the crime. And then what physical evidence is the prosecution bringing? If a murder has happened, was the person shot? Are they bringing the gun? And how have they been able to successfully link your clients to the gun? Have they done forensic evidence, or what have they done forensics, and all of that? So you need to consider all of that as defense counsel. That's the 3rd thing. The 4th thing is expert witness. Would you need expert witnesses, and have you been able to contact them? Or is the prosecution bringing expert witness? For instance, if it's a case of a crime of forgery, are they going to bring an handwriting expert, or something? Or are you the one going to bring an handwriting expert to prove the correct handwriting of your client? Would you need an expert witness, and have you contacted them or contracted them? You need to look at those things. So that's the 4th thing. The 5th thing is that you need to consider the crime and the elements of the crime and how you would disprove it, or if the evidence adduced or put together in the proof of evidence by the prosecution can prove it. You need to look at that. So the way to do that is to look at the criminal code, the penal code, or whatever law under which your client has been charged. I've said that for charges, usually there will be a punishment section. So what is under what section has this person been charged? So you need to look at it. Is it an existent law, or a law that's not even in existence, or a law that was created after the day the offense was the time the offense was committed? Those are things that can even get you out of the case in little time. So you need to consider all of these things. So you might not even need to use a defense. You will just come to court and tell the court, my lord, the law is not even in existence, they don't have a case, strike it out. So you need to look at that. So under what law has your client been charged and what are the ingredients of the offense. For instance, murder. For a person to be charged with murder in Nigeria, the prosecution or the state must be able to prove the following. One, somebody has died. Usually, there must be a dead body. Somebody has died. In some cases, there might be no dead body, but generally, there must be a dead body. And in all cases, somebody must have died. Whether there's a body or not, somebody must have died. That's one. Then two, the person must have died as a result of the action of the defendant. Whether your clients allegedly strangled them, beat them to death, poisoned them, or whatever, the person must have died as a result of the action of your client or action of the defendant or alleged action. And then three, there must be malice aforethought. There must be malice aforethought. Malice aforethought just means that it must be premeditated. That's for murder. Usually, when it's not premeditated, it's reduced to manslaughter. Like when there's been an accident and your client kills someone with their vehicle or something. So we can say that there's been an accident, they did not premeditate killing that person, so manslaughter. But for murder, there must have been malice aforethought. That is, you have planned and prepared to actually kill the person, and some other things that come into play. So look at these ingredients. How do you think the prosecution will be able to prove them? And how are you going to plan? And how are you going to disprove them in trial? You look at that. So that is how to prepare your defense. That's another way to prepare your defense. And then the fifth thing is police reports, witness statements, and their credibility. You look at that. So what statements have the police elicited? Was it elicited wrongfully or lawfully or illegally? For instance, was it gotten under duress? Was it gotten by, was it forced out of your client, forced out of the witnesses that the prosecution intends to use? Were they compelled? These statements being doctored? Police reports, the evidence adduced by the evidence put together in the police case file that the prosecution is relying upon. Look at them, because you get this thing as proof of evidence. Look at them. Are they probable? Are they things that can actually tie your client to the offense? And have they been gotten lawfully or unlawfully? Although in Nigeria, Musa Sadao and the state is still in operation, which is a decision that says that illegally gotten evidence is still admissible in criminal matters in court. But I'm not even talking about that now. What we're talking about when I talk about lawfully is that, for instance, a statement, was it voluntary or involuntary? So you can decide to rely on that my lord, the statement was involuntary. It was compelled or forced or obtained with force from my client or from the witnesses that they are relying upon, and all of that. So you look at that, the documents that have come in from the police, the evidence that has come in from the police, what's the quality of this evidence, what's the credibility, you look at that. And then the second to the last thing is that you look at who is the prosecutor handling this matter. You might not know that until you get to court, and you might even know that because usually, although it's because usually it's a different officer of the state that would draft the charge and sign it. In most cases, that officer might not be the same that will come to court to prosecute the crime. But the good thing is that in most settings, there's an officer attached to a particular court. So once you know that the case is coming up in this court, you're most likely able to guess that it is this particular prosecutor that is coming for the case. So what kind of person are they? What kind of practice do they have? What's their history? You can, look into that too. Of course, it can help you because you'll be able to predict them if you're able to understand their style. And lastly, you can look at the judge. Who is the judge that's handling this matter? If you know the court, of course, you should know the judge. So who is the judge? What's his disposition to this kind of matters, and what's his disposition to criminal trials? What's his antecedent and how can that affect, our case? So you look at that as well. And then let's talk about different defenses that you can use. I'm going to start from the one that I've mentioned earlier, accidents. The defense of accidents. That's for you to say that what your client did was an accident and not deliberate. I've talked on this channel once about the time, or maybe even more than once, about the time when we had a case at our law firm when I was practicing in another state, whereby our client, was delivering sand. He was a sand tipper, and he was delivering sand for a client. Then he ran into a slope. His truck was in a slope, and then he ran into a car lot, a car display or car sale lot, and then he hit some cars badly, and some, just a little bit. And then the car lot owner arrested him and had his truck with the sand in it detained at the police station. So we're trying to foster amicable settlement, but they were proving difficult. Apparently, we learned that they wielded some powers, at that particular police station. So while we're going back and forth, we were already considering our WATNA. WATNA is worst alternative. So what's the worst that could happen? They will charge this case to court because the investigating police officer gave us we were going to be defense counsel now in that case, so it's opposite. So the investigating police officer gave us an ultimatum for both parties to settle, or that they were going to file a charge in court. So it could go to the magistrate court, of course. So we were already planning that. We would just say it was an accident. An accident is a defense in law. It's a defense. So it's an accident. It did not intentionally run into your car lot. That place was slippery. So we were already discussing, our worst case alternative. So accident is a defense in law. So it's a complete defense too. So if you're able to prove that what happened was totally an accident, your client can get off. And it could even be the only strategy that you are going to rely upon, depending on what the charge is, and after having considered all other things that we've spoken about earlier. So that's one defense to use. Another defense is self-defense. Self-defense is you saying that your client actually committed the offense, but they did it in self-defense. So in that instance, you are telling the court, for instance, in a crime of murder, maybe the deceased person was trying to rape your client, and in self-defense, your client then struck them and then they died. So you can claim defense of you can claim self-defense. Your client can claim self-defense. Oh, they were trying to protect themselves. That's why they struck this person. There's no malice aforethought. They did not plan for this person to die, but this person was trying to hurt them. It just turned out that they were able to hurt the person first before the person could hurt them. So self-defense is another defense that you can rely upon, and it could be your defense strategy as a defense counsel. Then alibi. Alibi is another defense. What are you saying? At the time that this offense was committed, my client was at another place doing another thing with some other people who are actually here, or whom we can call here, my lord, to testify as to his presence with them. So you're saying that contemporaneously, the time that the offense happened, your client was in another place, not the day after the offense happened, not the day before the offense happened, not an hour after, an hour before, because it can come to that. It could even come to minutes, not minutes before or minutes after. That particular moment in time when the offense was committed, at 7:59 p.m., my client was at the other end of town, dropping off his sister at the airport when the offense was committed when the offense was committed at another end of town, at a bar. So that's alibi. So it could be your defense, it could be what you're relying upon. Now, the thing with alibi is that you have to raise it at the earliest point in the matter, that is at the police station. That's the earliest. So your client should tell the court. That's why if you've been charged with a crime or you've been arrested for something, get a lawyer immediately. Ask to speak with a lawyer. Connect with legal aid. Tell your family to get in touch with legal aid, or the office of the public defender or something, if you don't or cannot pay for a lawyer. So you need to talk to your lawyer to advise you as best as possible. So a defense like alibi cannot be brought into play as an afterthought. The court will consider it, but it will attach less weight and it might not get you off, because it's actually a complete defense that the police needs to investigate. So if you have mentioned it at the police station, the police can investigate it and find out that you are at a different place. You might not even go to court. You might not even need to go to court. And if you end up in court as well, you will be able to prove it. And the police or the prosecution will have to show to the court if they are still going on with their matter, even after you've raised alibi, if your alibi holds. Prosecution, we have to tell the court why, after having, investigated the alibi, they still went on to charge you to court. So alibi is a complete defense. Another defense is mistaken identity. So it could be that your descriptions match, that of a notorious criminal or someone that the police has been profiling or looking for, for quite a while. So you can prove the defense of mistaken identity, and it will get you off if you're able to prove to the court that you are not the person. You just have some features or some history or some maybe actions, that match, the actual that match that of the actual offender. So mistaken identity is also a defense. Another thing is reasonable doubt. I wouldn't say this is a defense, but it is also a strategy that every defense counsel should attempt. Plant reasonable doubt in the prosecution's case, because I often say that the job of a defense counsel is not to prove their client innocent. No, your job is to plant doubts and create reasonable doubts in the prosecution's case, such that the court will not believe them that you have committed the crime as a defendant, or as defense counsel as a defense counsel that your defendant, your client, has committed the offense. So it's like a leeway if you are able to create it, if you are able to work with it. Create doubt. Let's say this offense now, it's only probable that a tall person can do it. Your client is a short man. Even if you cannot completely prove it, plant it in the prosecution's case. Then let them go on a wild goose chase trying to prove that as short as your client is, they still committed the offense. So plant doubts, different types of doubts, and this will take you having sat down, critically thought about the case, thought about your client's story, thought about the probable story that the prosecution is running with, for you to be able to plant doubts in their case. So reasonable doubt, creating reasonable doubt is a way for you to get your client off, from the crime that they are being charged with. Let me add that strategy is important because under the law, your client is presumed innocent until proven guilty. So it is the job of the state, the prosecution, to prove your client guilty. So it's not the other way around. Let's say it was that your client was guilty until proven innocent, then you can be running after showing the court how innocent or how saintly your client is. But that is not the case. The case is that there's a presumption of innocence that is favoring your client under the law. So plant doubts in the story of these people that have come to say that he committed an offense. That's how to, defend your client. That's one way to defend your client. Another strategy is to show to the court, that the prosecution has misconducted themselves. When I say prosecution, it starts from the police. So you can show to the court that, police actually doctored evidence. So if the court is able to see that they've doctored some evidence, it will be difficult for the court to believe them all the way. Or you can show to the court that, they are actually profiling this person, maybe because of his color or because of his history. Maybe your client is a notorious criminal, but who did not do this particular crime, who did not commit this particular offense. So you can show that the police is just, witch-hunting him or profiling him. You can show that maybe they used extra force, unlawful force, during the process of arrest and investigation. You can show all those things to weaken the case of the prosecution. Very important. Another strategy is to to use the defense of mistake of fact, because mistake of law is not does not absolve anybody, but mistake of facts. For instance, if your client has been accused of theft, what if they took that thing in sincere belief that it was their own? Maybe your client had or has a dog, a brown dog with certain features that are matching that of the dog that was stolen. Now they've been accused of stealing or theft, and they've been charged to court. So you could be able to you could build a case to show the court that this person has a dog with the exact features or similar features, because nothing similar is the same. No look similar, them. I should go and trademark that saying. God knows how many videos in which I've said it on this channel. So if you're able to show to the court that your client was mistaken in fact, not in law, because that does not absolve anybody, then you might be able to get your client off. Another strategy is to go by way of entrapment. So entrapment means that the person was wooed, usually by law enforcement themselves, cajoled, encouraged, lured, propped up, propped or prodded by the police, by law enforcement themselves to commit that crime. So for instance, if someone was lured into, for instance, it could be that someone had committed the offense of, say, rape or defilement, but there's no evidence against them. Now, the person that is accusing them or the police themselves now lure them, creating or facilitating a repeat offense for them to now commit the crime so that they can record them and so that the recording can then be used against them in court. So that's entrapment. You might not get them off, but you might lessen, but it might lessen their sentence. So entrapment, maybe this person was lured by the police, by law enforcement, by anyone that is accusing them, for malice or, to get evidence to use against them, So entrapment is another strategy that you can use. Another defense is insanity. Insanity is a defense in law. For instance, if a woman has, say, baby blues, and it's the type that makes her hurt her baby, and she has been charged, to court for hurting the baby, you can claim a defense of insanity for her, because that's a type of insanity. So you're basically trying to tell the court or show to the court that if this person were in their right mind, they would never have done what they have been accused of doing or what they did. So you're telling the court that yes, they did it, but they were not in their right senses. So insanity. Another one is intoxication, showing that your client was under the influence of a substance, maybe alcohol or something, or drugs, when they committed the crime. So you're saying that they did it, but they were not themselves. They were under influence when they did it. So some of these defenses will just lessen the sentence, mitigate the punishment. They will not get your client off completely, but it's important for you to prepare, to use them as applicable. Another defense is statute of limitation. Statute of limitation. So there's statute of limitation to the crime. Usually, mostly in Nigeria, there's no statute of limitation for criminal matters. It usually applies to civil matters. It could be an offense created by the legislature, which might have a statute of limitation, or you could be in another jurisdiction. So to defend that crime, if there's a statute of limitation barring the prosecution from bringing a charge after maybe some years have passed or some certain conditions are no longer in effect, so you can come and tell the court that, my lord, the law says that you can't bring a crime of stealing against my client 10 years after the stealing occurred. It's been 10 years, my lord. My client has moved on. My client is not even in the state anymore. My client is not this, is not that, So statute of limitation could be a defense that you could use. Double jeopardy is another defense that you can use. It's you telling the court that my client cannot suffer twice. Double jeopardy, in fact, is a constitutional defense. The Constitution of Nigeria says that nobody should be tried by the same court for the same offense. So you are telling the court that, my lord, this person in 1998 was caught and tried for stealing a red Volvo car belonging to Mr. Ndubuisi, and they were sentenced to 10 years imprisonment. They have come out. This is 2022. And the police is preferring a charge against them for stealing a red Volvo car belonging to one Mr. Ndubuisi, again, in the same 1998, So when you're claiming double jeopardy, it has to be on all fours with the offense that they were tried for before. Whether they were acquitted, discharged, or convicted, and they have served their term, or whatsoever has happened to them. So that's a defense. You're telling the court that, my lord, my client, has been tried for this offense. So double jeopardy is a defense that you can use. Another one is Autrefois acquit, Autrefois convict. Oh, my lord, my client has been acquitted of this offense before. My client has been convicted of this offense before. Same court, same offense, not different offense. It's not that he stole a red Volvo belonging to one Mr. Ndubisi, and now he has stolen a black Jaguar belonging to the same Mr. Ndubisi, same victim, but different cars, so different offenses. That would not avail. Double jeopardy would not avail in this case. Autrefois acquit or Autrefois convict, which means my client has been acquitted at another time or has been convicted at another time for this particular offense, will not avail if it's a different act, a fresh act entirely. So those are defenses, and those are strategies that you can employ to defend your client as a defense counsel in Nigeria or even anywhere in the world as applicable. Another, strategy is false accusation. Has your client been falsely accused? If you can prove it to the court, you might be able to get them off. So get your facts straight and get your proof of false accusation. Get it in order to show to the court that my client is being wrongfully, falsely accused here. They never did what they have been accused of doing. That's another defense. That's another strategy. Necessity is another strategy that you can use. It's a defense where you're telling the court that my client did this thing, but it was out of necessity. For instance, someone is running towards danger that could kill them, and then you did something to them, which is a crime, but which maybe merely just hurt a finger or hurt a toe, which has now saved them from being totally killed. So you're telling the court that I did it out of necessity. They were in danger of immediate harm. I was trying to save them. So this is a lesser evil, and it was not deliberate. It was to protect them from a greater evil. So necessity is a defense too. So we have spoken a lot. This is a long video. I hope that you watched it to this point. So what exactly are you going to do when you're trying to defend a crime? And this for you as a defendant or for a defense counsel. What's your plan? What's your strategy? Are you going to use a defense in law? Are you going to discredit the prosecution's witnesses? Are you going to disprove, the documents or discredit the documents that are being tendered by the prosecution? Do you want to use an alibi? You want to show that the prosecution has not proved or led evidence in support of a key ingredient of the offense? Or do you want to plant doubts, sow seeds of doubts in the defense, in the prosecution's case? These are different ways by which you can get your client off the hook. Remember, when you're practicing your defense, preparation is key and fear of God is key. I will see you in my very next video. Don't forget to subscribe to those.